Monde qui pour représenter au domaine légal. Cabinet avocat Jonathan Kane avec Franz Vital, réputation solide, l'a occupé les affaires immigration, divorce, child support, avec tout cas légal. Des pour faire un accident machine ou sinon accident travail, maître Jonathan Kane avec maître Franz Vital, des capacités pour y aider. Il travaille dur pour y faire jouer une compensation que dommage, il fait souvent mérité. Il faut connaître, si on pas joindre l'argent pour vous, même tout, il pas touché. Qui donc, ils obligé de travailler pour qu'à fois toucher, et tant qu'on touche plus, c'est qu'on s'est à toucher tout. Pas d'accident qui est trop petit, mais relais connu, quel que soit accident gagnant, maître Kane ou soit maître Vital, deux offices pour servir. Braod, 6190, Nord-Ouest, 11e Street, dans Sunrise, téléphone 954 723 51 23, dans North Miami Beach, 162 10, Nord-Est, 11e Côte, téléphone 305 545 51 23.
Good morning and welcome to What You Need to Know About the Law. As you know, my name is Jonathan Kane, and we bring you what you need to know every Saturday morning here live from the office. And as you know, we can be reached anytime at 954 523 5123 or 305 545 5123. Again, 305 945 523 5123. I would tell you, as I always do, put it in your phone, maybe put it in your wallet. And that way, if you need us, we'll be there for you anytime. 954 523 5123.
Bonjour, chaque samedi matin nan même le sa yo. Avocat Jonathan Ken toujours prend plaisir pour venir faire parler avec nous concernant tout ça que nous t'a dû connaître sous affaire la loi. Il mettait le facile pour nous visiter bureau li, pour nous parler avec lui. Il donne nous consultation gratuite. Téléphone ça yo toujours disponible, nous capable briller là-dedans yo. 954 523 51 23 305 545 51 23.
This morning, I wanted to talk a little bit about something that I know is an issue for people out there, and that has to do with cases with regards to employment cases and employment law here in Florida, which can unfortunately be very tricky.
Matin, nous devons parler concernant règles du travail, ou loi qui gère affaires travailler avec boss travail, et nous connaissons pile problème comme ça en Florida.
It is very tricky because Florida is what we call an at-will employment state. And that means that an employer can terminate an employee for almost any reason, or actually no reason at all, as long as it's not an illegal reason. And there's some exceptions that I'm going to go over today, but this is the big issue. And we get calls all the time. So it's important we go over this once in a while, and that is the fact that we're an at-will state. And again, that means your employer can terminate you for almost any reason, or they don't have to have a reason at all.
Alors, Florida, c'est un état côté que travail yo, pas besoin aucune raison pour yo dire non, yo pas besoin non travail pour yo encore. Or, si que yo ta dit non, yo pas besoin de travail, depuis que ça yo dit, ali pas aller à l'encontre ça la loi dit.
Now, there are some exceptions to make causes of actions that do allow employees to challenge a wrongful termination. And this morning, I'm going to go through the different types of actions you may have. Again, these are not common, but there are types of claims that you can make if you feel like you were illegally terminated.
Kon gen lot circonstance kote ke gon bagay ko kapab fè si yo revoko non travay e ke revokasyon tombe sou paket rubrik sa yo ke Met Jonathan Ken pral pale nou sa yo ye.
Now, one of the things that in Florida they cannot do is fire you based on discrimination, based on a protected characteristic or what we call a protected class, and that includes being discriminated against by race, religion, or national origin.
Alors yo pa kapab revoke nou e pou yo utilize des méthodes discriminatoires ki gen rapport avek ras, koule nou, origine nou, ou lang nou pale.
It also includes sexual harassment if you're being discriminated on because of pregnancy or in any other sexual manner, religion or disability, and also age. If you're over 40 years old, you may have a claim for discrimination based on age discrimination.
E yo pa kapab utilize religion, yo pa kapab utilize l'âge comme cause pou yo revoko non travay pou yo di ke sa yo ap konsidere comme bagay ki discriminatoire.
One of the other areas that they cannot fire you for if you're terminated because you engaged in a protected activity, such as they can't retaliate. So if you file a discrimination complaint internally with the company or with the EEOC, the government, they cannot fire you in retaliation.
E si ou mèm ou tapote yon complainte son bagay ko pense ki yon raison discriminatoire avec département l'État et EEOC, eh bien travail la pas capable utiliser parce que ou al pote complainte ça comme prétexte pour revoker peut-être ça.
Also, if you're participating in any type of investigation because of the workplace misconduct, if the government's involved, they can't retaliate against you, and they cannot fire you or retaliate for requesting or taking a medical leave of absence under the FMLA, Family Medical Leave Act.
Si ou mèm ou participer nan yon investigation quelconque qui gen rapport avec condition travail nan travail ou, le travail la pas capable utiliser ça comme moyen pour yo révoquer ou, et ni tout sou gon cause qui fait qu'on capable prendre yon absence médicale pour une période de temps, yo pas capable révoquer ou parce que ou mandé pour yo ba ou leave of absence ça.
Another violation would be retaliation if you complain to the government about a safety violation under OSHA, or if you did some kind of whistleblower claim where you're claiming your company was committing fraud or waste or illegal activity against the government. We've talked about these claims. These are whistleblower claims, and these are all retaliation if you're fired for doing any of those types of activities.
Et si ou mèm ta revoke nan travail, soit parce que travail la gen kek bagay li ap fait qui illégal, qui contrairement à la loi, et que ou ta collaboré avec gouvernement pour investiguer travail ça, et que ou même ta utilisé prétexte ça pour ta revoke, ça li illégal.
Another exception to the rules is if you have a contract with your company. Not everybody does. It's pretty rare for an employee to have a contract. But if you have a contract, an employment contract that guarantees your job security or that creates an obligation on the company to do certain things before they terminate you, then you may have a claim for wrongful termination based on the contract, based on the agreement you signed to work for that company.
Alors si ou même bien que ça li très rare, ou ta gen un contrat avec une compagnie, et dans contrat a gen condition de travail yo, alors avant que contrat ça ta terminé, eh bien ou décidé à casser contrat ça et à révoquer ou, là ça ou capable gen recours à la justice sur ça.
You also cannot be terminated for public policy reasons. If you file a workers' compensation claim, it is illegal to fire you based solely on the workers' compensation claim. If you're fired because you're required to serve jury duty here in Florida, that also is protected by the law. And if you file a wage and hour claim, an overtime claim, and we'll talk about that in a few minutes, those are also protected. They cannot fire you based on retaliation.
Et si ou même ou ta appliqué ou ta fait un claim pour overtime parce que tu travailles pour yo dans période requis pour ça et que yo pas payé overtime non, yo pas capable d'utiliser ça comme prétexte pour yo révoquer ou parce que yo réclamer pour yo payer ou comme pour overtime non.
There's also some protections if you're in the military, they have to keep your job open. But the bottom line is there's no general cause of action here in Florida for simply being fired unfairly. Instead, if you're going to make a claim, it must be tied to one of these specific laws, either discrimination or violation of family medical leave or violation of a contract.
Alors si que nous-mêmes que yon bagay kon sa ta arrivé non et cause là ta gen rapport avec sujet qui permettent que nous capable mener une action parce que c'est discrimination ta et bien ça nous capable mener autre que ça pas gen l'autre bagay que nous capable faire encore dans Florida.
Now, one of the things that we've talked about in the past that is a protection that every employee has, and that's a protection based on federal law, and we call that law the Fair Labor Standards Act, which was enacted back in 1938. So it's been around for almost 100 years.
Alors, il y a l'autre qualité règlement du travail que vous êtes supposé respecter dans la loi que vous avez déposée là et qui parle presque 100 ans, en 1938.
And what the FLSA, the Fair Labor Standards Act, does is it gives us baseline rules on how employees must be paid. And unfortunately, even though these laws have been in place for over 100 years, every day there are violations, especially in industries like restaurants, hotels, construction, and healthcare.
Alors, bien que la loi ça yo là pour indiquer qui gens sont capable payer moun qui a travaillé et loi ça gen presque 100 ans depuis là, mais toujours gen dispute, toujours gen problème dans moun qui travaille dans restaurant, dans hôtel, dans genre de côté ça yo pour yo calculer paiement pour yo.
Now, the first protection you're going to get under the Fair Labor Standards Act is it requires that employees receive at least the federal minimum wage, which here federally is $7.25, but here in Florida, minimum wage is higher due to what we approved in our Constitution. So now, as of right now, September 2025, Florida minimum wage is $13 per hour, and that's going to increase by $1 each year until it reaches $15 an hour by the year 2026.
Alors, li mande que si un moun li ap travail, eh bien, moun sa li ta supposé toucher salaire minimum qui dans le temps était à $7, mais kounye avec nouvelle loi qui vient prendre en Florida, li a $13 et chaque année, li a monté à $1 jusqu'à ce que li vienne à $15.
And it's important to understand that if you are not paid minimum wage, this may be construed as a minimum wage violation, and you may be entitled to make a claim under the law. So in Florida, they have to pay you legally at least the minimum wage. If your employer deducts costs for uniforms or equipment or cash register shortages, these can sometimes put you under the minimum wage requirement, and that's unlawful.
Alors, si yo même yo pas ta payer au salaire minimum ça, eh bien, li contrairement à règlement yo, li qui vient contraire à la loi, nous gen recours, nous gen bagay nous capable faire pour ça.
Also, they can't have you working off the clock. If you're required to show up early or clean up after your shift or handle prep work without being paid, this may be counted towards your minimum wage, and this too could be a minimum wage violation.
Et si nous-mêmes nous non travail côté que les nous fin puncher, yo fait nous faire l'autre travail que yo pas contrôler pour yo payer nous. Ou les nous vinn travail avant nous commencer yo bonne font paquet l'autre bagay avant que nous puncher. Eh bien tout temps ça yo capable contrôler yo pour l'aller sous montant tant que yo doit payer nous salaire minimum. Et si yo pas fait ça, c'est une violation du code de travail là sur ça.
And sometimes companies will mislabel an employee as an independent contractor, and they do that to avoid paying minimum wage or overtime. And we have to look at the actual job, the reality of the job, not just what your boss calls you. Just because they tell you you're an independent contractor, the law defines it very specifically. So very often people are mislabeled as independent contractors, and that's to try to save money on taxes, minimum wage, and overtime.
En pile fois qu'on gen travail yo, pour yo éviter pour yo pas payer nos salaires minimum, ou si nous travail overtime pour yo pas payer nos overtime, yo dit nous c'est un indépendant contracteur que nous y. Laisse ça vraiment dans job description ça n'a fait nous pas aucun minimum, nous pas aucun indépendant contracteur, c'est un travailleur qui a travaillé par heure que nous y.
Now, let's talk about the main reason we talk about the Fair Labor Standards Act. The reason being that so many of you have been ripped off over the years, and we've been able to help so many people. And that is that the federal law requires that most employees, you have to be non exempt, and we'll talk a little bit about who's exempt, but for the most part, most hourly workers and even salaried workers who work more than 40 hours a week are entitled to time and a half their regular rate for every hour they work more than 40 hours in a work week.
Tout moun ki travay nan une semaine, 40 heures de temps, à salaire minimum, mais tout son travail en plus que 40 heures de temps, eh bien c'est overtime lié, yo supposé payer au plus l'argent pour ça.
And where we see big issues is that salaried employees are not always exempt. Just because your company pays you a salary doesn't mean you're not entitled to overtime. If your duties don't fit into the exemption, and that requires either an executive or administrative or professional role, then you still would be entitled to time and a half. So if you're not able to hire and fire, make decisions about the company, you're not managing the company, even if they pay you a salary, if you're working more than 40 hours a week, you may be entitled to make an overtime claim.
Même là que yo ta faut comprendre son boss ko yé, et que wap travail, mais de pou pa gen pouvoir pour ni employer, ni révoquer, ni faire défaire dans compagnie, eh bien si yo faut travail plus que 40 heures de temps, eh bien tout son travail en plus là, yo doit payer au lit comme overtime.
We also see sometimes employers automatically deduct meal breaks, even if the employees are working through their meals, and they edit the time records to reduce the hours. That's a violation of the law. If you're working through lunch every day, that extra hour, you're entitled to time and a half as long as you work more than 40 hours a week. Another thing that we see that people don't realize is a violation is working off the clock. If you're answering emails at home, or you're loading a truck after your shift is over, or you're doing prep work and cleaning up before cooking before you start your job, those are all compensable times. They must be paying you for that time. They can't tell you have to come in an hour early to do the prep for cooking and not count that as hourly time. So again, if you're working more than 40 hours a week, they do owe you time and a half for all the hours you're working more than 40 hours a week.
Toutes les fois que vous avez fait nos travail, avant le travail, nous, pour nous faire une préparation pour le travail là, pour nous capable commencer, or, nous fin travail, yo dit nous faut nous nettoyer après tête nous, les nous fin puncher, eh bien, toutes les ça yo supposé contrôler dans temps travail nous, et si yo dépassé 40 heures de temps, yo supposé payer nous overtime pour yo tout.
Another things employers like to do is they split the hours up into different weeks. So if you're working 60 hours a week and they try to split it into 2 30-hour weeks to avoid overtime, the law doesn't look at what they say. The law looks at the worksheet, not the pay period. So they're going to, again, see if you've worked more than 40 hours in a particular work week, and that would give you entitlement to make a claim for overtime.
On l'autre gens que qu'on fait, si nous travaillons 60 heures de temps pour semaine, au lieu que vous fait nous toucher dans semaine, comme ça, vous coupez l'en deux, vous fait 30 heures de temps dans semaine, ça, 30 heures de temps dans l'autre semaine, ça, cap venir. Non, il faut pour pas payer nous overtime. Mais les a considéré, il pas garder qui j'ai séparé, il garder dans semaine combien l'heure que nous travaillons. Tout ça qui en plus que 40 heures de temps, tout c'est overtime que vous.
Now, they do have special rules for tip workers, such as servers or bartenders or people that work in a hotel. The employer can pay a tip worker lower cash wages. Here in Florida, the minimum wage for hotel and restaurant workers that get tipped is $9.98 per hour. And as I said before, the minimum wage is $13 an hour. So there is a credit of $3.02 per hour. And I don't think people know this, but if you're a tipped employee and you don't make up to $13 an hour, so if your tips plus the wages you get don't make $13 an hour, your employer is required by law to make up the difference between the $9.98 and the $13 minimum wage.
Alors, moun kap travay nan restaurant yo, nan kote ke se sou yo recevoir tip, eh bien, travail là, salaire minimum, c'est $13 que lié. Alors, si yo contrôle tip yo, chaque temps à cob que nous toucher, s'il pas équivaut à $13, eh bien, travail là, li responsable pour payer nos différences là.
If you're working in a restaurant, there are things that are illegal. It's illegal to do pool tipping where managers and supervisors and everyone else is sharing in the tips. That can be illegal. Also, it's illegal for a restaurant to have the servers doing excessive side work. If you're doing more than 20% of your time doing cleaning and rolling silverware and stocking supplies, if that work takes up more than 20% of your time, then they cannot pay you the $9.98. They must increase your wages to the 13 minimum wage.
Sou son moun si son serveur yo ou waiter, men pendant tant qu'on ap travay la, ou gen plus que 20% de travail qu'on fait qui ale soit nan préparer table, nan mette argenterie ensemble, jan de bagay sa yo, eh bien si c'est comme ça, yo supposé payer au $13 et par heure, parce que c'est ça le minimum nan pralier pour ou, parce que c'est pas servi ou gen 20% de temps nan service ou qui passe nan fait bagay sa yo.
I would tell each and every one of you that's listening this morning, and if you have family members that are working, grab your pay stub and just take a look at it and see if your pay stubs are matching up with the time you're working, and make sure that if you're working more than 40 hours a week, that they're paying you time and a half for those extra hours. That is your money. It is money you are owed, and you're being ignored and ripped off if you don't do anything about it.
Li très important pour nous même qui ap travail dans côté ça yo nous garder 4 que nous ponche pour nous voir que sinon une semaine nous travaille plus que 40 heures de temps, mais en dépit du fait que ça yo pas jamais payé nous overtime pour temps qui en plus que 40 heures de temps, eh bien là ça n'a connaît gen bagay que nous capable faire pour nous retrouver l'argent ça yo.
And what's great is if you hire a lawyer, what the lawyer is going to do is they're going to, number one, file the claim for you. They can file the claim with the Department of Labor. Sometimes they do it directly with negotiations, and most of the time it's filed in federal court. And your lawyer is also going to be able to protect you if your employer fires you or punishes you for asserting your rights. It's illegal, to retaliate in a overtime claim. So if you file a claim for overtime or minimum wage violation, they cannot retaliate against you, and that's what your lawyer is going to do for you.
Alors si nous-mêmes nous déposer une complainte parce que nous travaillons overtime et que travail là pas payé nous, et nous prenons un bureau qui pour travailler pour nous récupérer l'argent ça, eh bien yo même yo pas capable d'utiliser action ça que nous fait comme cause pour révoquer nous dans travail là.
Now, why do I talk about this law all the time? Because first of all, if you're not getting paid by your employer what you're entitled to, they're breaking the law and they're ripping you off. So this law was designed to make workers whole, but also to punish employers who break the rules. So the good news is when you file one of these claims, one is you're going to be entitled to the unpaid wages, the difference between what you were paid and what you should have been paid. They're going to pay you back all of that overtime.
C'est important pour nous comprendre ça yo. Si toutes les fois que nous gagnons temps overtime, que yo fait nous travail, ou que yo utiliser une autre méthode pour faire nous comprendre que temps nous pas supposé faire overtime, dit pas overtime, et que nous prenons un avocat qui pour gérer ça pour nous-mêmes, eh bien, les yo réussi dossier ça, y a payé nous pour tout temps overtime, yo que yo te doit payer nous, et que yo pas payer nous, yo fait notre travail tant que c'était rien n'était.
And the good news is there's also what we call liquidated damages. In most cases, you're going to get more money than the unpaid wages. Usually, it's 2 times the unpaid wages. So, for example, if you're owed $4,000 in overtime, most of the time your case will recover minimum of 8,000. So they're going to give you your money back, but they're also going to punish the company for breaking the rules.
Alors, si que yo ta dwe nou montant pour overtime, après que yo fin fè ça qui nécessaire pour nous retrouver li, on essaye di, si c'est à $2,000 yo ta dwe nou, eh bien, si nous obligé à prendre avocat pour faire ça, c'est double la valeur que yo pral dwe nou kounya, yo pral gen pour payer nous 4,000.
Now, the one thing that's very, very important to know about overtime claims is there's a limited time that you can go back. You can usually go back up to 2 years. If it's a willful violation, if you can prove they did it on purpose, you can go back 3 years. But the reason I bring this up is you can only recover up to 2 years from the date you file the lawsuit to recover your money. So if you were fired 6 months ago and you think you're entitled to overtime and you're waiting, instead of being able to get the 2 years from the lawsuit, you're only going to get a year and a half. So there is a time limit, and this one's very, very important that you get on it as quick as possible because they can go back up to 2 years. If you're still working there, then that's not too much of an issue. But if you've been fired and think you're entitled to one of these claims, you have to get on it as soon as possible because there is only a 2-year period that you can go back. And the longer you wait, the less that period's going to be.
Alors, il est important pour nous comprendre que si nous gagnons un temps overtime que nous travaillons dans la compagnie, eh bien, nous gagnons jusqu'à 2 ans pour nous réclamer comme ça. Alors, si nous quittons plus que 2 ans fin passé, nous pas faire réclamation, nous pas faire rien pour nous récupérer l'argent ça, then nous pas le joindre.
And you know what the best part of this law is? That this law has one of the strongest attorney fee provisions in employment law. If you win, and even if you recover a small amount, your attorney is going to be paid by your employer. You don't pay any out-of-pocket monies for the lawyer in most cases.
Alors, bagay qui est important dans ça, à part de nous-mêmes qui recouvrir 2 fois la valeur des cob qui ont été doués nous, mais il y a payé service avocat qui fait processus ça pour nous capables de toucher l'argent.
And again, this is great because number one, you don't have to pay anything. And number two, usually the fees are going to be a lot more than what you're paid as well. And they do that because it's intentional. The law wants to encourage workers to enforce their rights so they get a free attorney. And they want to make sure that if these companies violate the law, that they're going to be punished. And the punishment's going to be paying you 2 times what they owe you, plus all of the fees and costs for your attorney.
Alors, tout processus ça qui est en place, ça c'est pour décourager le travail, pour ne pas prendre avantage de nous-mêmes dans ce sens ça, pour faire notre travail overtime, yo pas payer nous, faire nous comprendre si rien n'était. Et si que nous-mêmes nous travaillons pendant un paquet de temps et que nous avons tout comme ça que nous devons, eh bien, nous sommes capables de comprendre que nous sommes capables de recouvrir 2 fois la valeur des cob là, plus dépenses pour avocat et faire pour arriver dans l'argent ça, et à payer avocat pour service li.
Some examples of these are there was a group of restaurants in Miami that was sued because the management was requiring everyone to share tips with the kitchen, and those workers did get their back pay plus double damages. Another big one was up in North Florida in Tampa, where a construction company was calling all of their workers independent contractors and not paying overtime. Well, the court found they were employees and awarded each of those employees 3 years of unpaid overtime, doubled, plus the liquidated damages.
Alors, nous voyons qu'on gagne sens côté que gagne satisfaction, moun yo capable de recevoir, te gagne restaurant dans Miami, côté que moun yo qui te gagne type que a mette pour eux te faire séparer là avec moun qui dans cuisine yo, bien que ça pas de fait, et bien yo te fait un lawsuit, et bien moun ça te capable de couvrir damage.
So again, you don't pay for your lawyer and you get money that you've earned. Another example is a retail worker that was forced to work during their lunch break. The employer ended up having to pay thousands in unpaid wages and attorney's fees because of it. So in my opinion, this is one of the strongest tools that you employees here in Florida have to protect the right to fair pay, to minimum wage, to overtime, to your tip wages. These are all covered by the law.
Gen an pil ekzamp nan moun ki travay ou ki ta de touche overtime, ki pa touche e nan lot aksyon ke yo bay ou de klasifikasyon ki pa reyelman klasifikasyon pou yo kom travaye ou fè ou kompwen yo se kontrakte indépendant. Ebyen nan lò sout sa yo moun sa yo te arrive a touche doublement l'ajan ke yo te kon fè, plus depans ke avoka yo fè, plus l'ajan pou servis avoka ki rive a konklusyon sa yo.
I tell you very honestly, if your paycheck doesn't seem right, if you're working a lot of hours and not getting overtime, if your tips don't seem to make sense, or if they're taking money away from you and you're not making minimum wage, you have legal rights. And remember, you can only recover these cases if you come to us and tell me. So take the time, check your pay stubs, and just make sure that your company is doing the right thing.
C'est très important nous mêmes qui a coûté là. Si nous gagnons un cas overtime comme ça, nous mêmes qui capable aider avec ça, nous pas connaître. C'est vous même qui pourrez les bureaux pour parler de ça avec nous. N'a bonne consultation gratuite, passer avec si chaque jour pour nous capable de gérer ça.
Avocat qui comprennent qui haïtien c'est les n'a choisi un monde qui pourrait représenter dans le domaine légal. Cabinet avocat Jonathan Ken ak Franz Vital qui réputation solide dans occuper des affaires immigration, divorce, loan modification, foreclosure, accident de travail, accident automobile ak tout l'autre cas légal. De pour faire un accident machine, osno un accident de travail, relé met Ken ak met Vital, yo gen capacité pour yo aider ou. Yo travail dit pour yo jouer une compensation dommage ou gagnant mérité. Yo tellement sérieux, si yo pas jouer l'argent pour vous, yo même yo pas toucher. Qui donc yo obligé de travailler pour capable jouer l'argent. Et tant ou toucher plus, yo plus content. Pas d'accident qui trop petit. Relé kounia pour quel que soit accident. Mettre Vital qui des offices pour servir. Dans Broward, 6190 Northwest 11e Street dans Sunrise. Téléphone 954 523 51 23. Dans Miami même, 170 Northeast 11e Court dans North Miami Beach. Téléphone 305 545 51 23. 305 948 77 55. Et puis, pas oublier, consultation yo toujours gratis.
All right, we're back to what you need to know about the law. And reminding you, if you have questions about wage loss or overtime or any kind of questions about the law, we give a free consultation. All you got to do is take my phone number and put it in your phone or write it down and put it in your purse or wallet. And of course, that's 954-523-5123 or 305-545-5123. I do ask if we're unavailable and I can't answer the phone, please leave me your name and your number, and I'll call you back.
Tap koute avocat Jonathan Ken dans cabinet Ken Vital. Information ça le pote pour tout à fait gratuite. Consultation avec avocat gratuite. Chita parler avec yo gratuite et yo toujours disponible pour entendre des problèmes et puis capable aider joindre une solution pour yo.
Because it's so important, I'm just going to give you a brief, again, telling you what the Fair Labor Standards Act is going to cover for you. Number one, non-payment of overtime. That's the most popular one we see, and that is because if you're working more than 40 hours a week, they have to pay you time and a half for all the hours that you're working. Sometimes they're neglectful. They don't do it on purpose. Sometimes they just refuse to pay in such industries like construction or food employees. But the law is very clear. If you make more than 40 hours a week, you are owed time and a half under most circumstances. So again, check your pay stubs and make sure.
Et si ou même son moun qui a travail dans n'importe qui travail, eh bien ou même ou travaille plus que 40 de temps là-dedans, eh bien c'est pour très certain pour garder pour est-ce que vous payez overtime. Si vous pas payé overtime, ou gen bagay qu'on capable faire pour ça et la loi a permettre qu'on capable récupérer tout l'argent ça yo.
Probably the other most common thing that employers try to do is to classify employees as independent contractors rather than employees. And this keeps increasing every year. And the reason being that the job, they want to make sure they don't have to pay for workers' compensation or unemployment insurance or your Social Security and your Medicare. If you're an independent contractor, the job saves a lot of money, but it certainly is not good for you, the employee. So it is illegal for a company to call you an independent contractor to avoid paying taxes and other benefits.
Alors, ou même qui a travaillé pour compagnie ça, des fois, ils vont chercher dire ou son boss ou son contracteur indépendant, eh bien, pendant tout ce temps, c'est travail, ou fait travail normal. Eh bien, ça, c'est un bagage qui est fait pour empêcher, pour ne pas payer overtime, pour ne pas payer taxes pour eux-mêmes, et pour ne pas avoir l'argent pour overtime.
And when I say independent contractors, there is a specific law that tells us what an independent contractor is. And it's not just because your job says you are. An independent contractor is exactly what it sounds like. You're independent. You don't work for that job, but there has to be more to it. They have to show that you can work for any job and you work for other companies and you're only working there part-time. If you're working 40 hours a week at a company and they're calling you an independent contractor, chances are you're not.
Alors, gagner des descriptions que vous faites ça un contracteur indépendant. C'est pas parce que travail là d'où son contracteur indépendant qui fait ça. Parce que si vous même travail pour comme un indépendant contracteur, ou pas un travailleur, ou pas un travail là, ou capable de travailler pour paquet d'autres compagnies en même temps ou l'autre fois.
And the last one we talked about is minimum wage. If you're an hourly employee, you're entitled to the highest rate of pay that is mandated by the government. And here in Florida, it's $13. However, some employers don't follow these guidelines and pay their employees less than minimum wage. And I am telling you that's illegal. You can sue them and get back your money that is owed, plus sometimes double that amount. And the attorney's fees are paid for that illegal act by the employer. So if you're a tipped employee and you think your tips are not adding up to the $13, remember, they have to compensate you the money in between those dollars that you're not getting. So all of these would be minimum wage violations, and all of them would give you a right to make a claim.
Alors, si son moun kap travay nan restoran, nan hotel, nan kote ke yo bo tip, eh bien, sous travail et ak salaire minimum qui $13, le yo ajoute tip pour yo pour chaque heure, eh bien, li pa fait $13, eh bien, travail là, li responsable pour li payer différence là, de manière pour capable rete nan salaire minimum qui kounya nan Florida à $13.
And of course, another one is working off the clock. Hourly employees begin when they clock in and when they clock out. And that includes time spending. They can't have you come to early to prepare for your job or clean up before you go home. These are all part of your job and they have to be on the clock. You shouldn't be required to do these activities off the clock. So if you work for a restaurant and they tell you that you start at 7, that they want you to come in every day at 6 to do the prep work for the night shift, they have to pay you for that. So you can't be asked to work off the clock. You can't be asked to work through lunch and other break times and then not pay you for that.
C'est important pour nous comprendre si nous travaillons pour un restaurant, pour un hôtel, on va quelconque, nous avons fait préparation avant l'autre et coup à venir. Eh bien, si le travail nous c'est à 7h du matin, eh bien, ils dit nous venir à 6h pour nous préparer, eh bien, ils supposé payer nous pour une heure de temps ça que nous travaillons, soit avant ou après le nous finir.
And this also counts because we get a lot of these calls. If you work for someone and they didn't pay you at all, this is wage theft. We call it wage theft, but that is a minimum wage violation. And if an individual is hired to work for an employer, they must be paid. And that includes the last paycheck. If the employee is terminated, all the days worked, all the hours worked, including any of that is covered. They can't not pay you if they fire you. That is a violation of the minimum wage requirement, and you can sue for your last paycheck as well.
Alors, si vous travaillez un côté, vous révoquez, yo pas capable prendre ça comme prétexte pour dernière semaine côté travail là pour yo kembe l'argent pour yo pas payer ou. Si yo t'a fait ça, eh bien ou gen recours ou capable prendre avocat pour yo payer ou.
Another area of the law that you might be protected and you should know about is understanding the Family Medical Leave Act, the FMLA, which is a federal law designed to protect workers who need to step away from their job for their family or medical reasons.
Alors, il est important pour nous comprendre qui Jean Family Leave Act là lié parce que yo pas capable révoquer nous parce que nous mandé période ça.
What the FMLA does is it gives employees up to 12 weeks of unpaid leave. They don't pay you while you're gone, but your job is protected. So as long you have 12 weeks every 12 months for certain family and personal medical situations. If you take the leave under the law, your employer must continue your health insurance as well as keep your job available.
Alors, si que ou une raison qui fait qu'on a besoin espace ça, ou besoin temps ça, eh bien, pendant que vous prenez, travail là, il doit maintenir assurance si vous gagnez avec eux, et il doit kembe position pour leur retourner.
Now, who's covered? Not every employee or employer has to deal with FMLA. To be covered, private employers must have at least 50 or more employees within a 75-mile radius. All public agencies, federal, state, and local, all of those are covered under the FMLA. So if you're a teacher or work for the county or you work for Jackson, you're all covered.
Alors, pour vous-même, capable participer dans ça, faut compagnie ou travail la gagne 50 moun k'ap travailler ou plus.
Another thing, to be eligible, you must have at least 12 months of employment with the company, not necessarily consecutive, doesn't have to all be at once, but at least 1,250 hours worked for that company in the 12 months before you ask for the leave. So you do have to have at least 50 employees, and you do have to wait typically about a year to be eligible.
Alors, pour éligible, faut qu'on travaille pendant 1 an ou plus pour compagnie ça, avant qu'on capable faire demande ça.
With regards to reasons to leave for FMLA, well, childbirth is a big one, and that includes the father as well. They can take FMLA to bond with the child. That also goes if you're adopting or fostering a new child. That is the same as birth. You can ask for those 12 weeks of time to be with your child and help that process.
Alors, ni maman ni papa capable faire demande ça, soit les rapports faire un nouveau petit, ou si y a pas adopté un petit monde, il a besoin de temps pour capable acclimater avec tout le monde.
It's also there if you have a serious health condition that prevents you from performing your job, you get hurt on the job or you get sick and can't go to work, you can file for FMLA.
Alors, si vous même son monde qui a une maladie et que vous pas capable de travailler pour une période, ils sont capables de réclamer et leave of absence ça.
And then the other one is if you have a caring for a spouse or a child or a parent with a serious health condition, that too would qualify you for FMLA. So it's either you have a medical condition or a loved one, and you can apply for it.
Soit ou même sous une condition médicale qu'on a besoin de temps, ou sous un monde dans la famille qui malade et qu'on a besoin de temps pour occuper ou capable demander.
Now, you can't just not show up. You do have to apply for it. You have to request it and give your job notice. Typically, you must give at least 30 days notice. Obviously, if it's an emergency, then you have to let your employer know as soon as possible.
Et bien, vous avez pour 30 jours d'avis si vous prend temps ça, mais si c'est une urgence qui passe et qui fait qu'on n'est pas capable de venir, then aussitôt que possible, vous supposez faire au connaît.
You're also going to probably require some paperwork from the healthcare provider confirming that you need the leave or that one of your family members needs help. And the employer then must respond to you, and they're going to have to let you know if you're eligible. If you're not eligible, they have to give you written notice of why and also written notice of your rights and responsibilities under the law.
Alors, si vous faites demande ça, eh bien, boss travail la compagnie a bien pour examiner demande non, pour yo wè est-ce qu'on remplit condition pour yo ba ou et livre absence ça. Et dans le cas qu'on pas ta rempli condition, then yo supposé expliquer ça par écrit et ba ou sa responsabilité ou devoir envers yo-même.
They cannot deny a legitimate request or misclassify your absence. If you feel like you've been retaliated against, you can make an internal complaint and start with the HR or management, try to resolve it with them. If not, you can also file a claim with the Department of Labor. And then finally, and the easiest is to contact a lawyer or call my office, and you can file directly in court without going through those other processes.
Alors, dans le cas que ou même ou ta ou moun qui t'a besoin genre de service ça yo pour affaire FMLA, ou soit capable contacter bureau ici à sous ça et ou capable contacter avocat qui résout le problème ça yo et après content capable aider avec lui.
And the type of claims that you can file a lawsuit is just purely wrongfully denying the leave, or if they retaliate against you for requesting to take the leave, those are both illegal. And then it's also illegal if the employer fails to restore you to your same job or position. They may be able to change the time, but they can't take you from manager and then send you back to salesperson after you take your leave.
Alors, si que ou même ou t'a fait demande ça et que yo même yo a cherché passer par la tangente pour yo pas ta ou li, eh bien le ça ou capable gen recours ou capable faire. Ou si yo ba ou li faut absence alors retourner position TR mettons leur position qui pi bas, tout ça ou gen recours capable chercher gérer ça yo.
And if you win, the court may order that they reinstate your job, give you your job back. They may pay you lost wages and benefits that you lost. And in some cases, you may be able to get liquidated damages, extra money if you can prove that your employer acted in bad faith. If they did it on purpose, there may be additional monies. And the other thing that's good about this law is the law is a fee shifting law. So if you win, they're also going to have to pay your attorney's fees and costs for the attorney to sue them.
Alors, ça qui est important, c'est que si que nous-mêmes nous besoin genre de service ça yo, eh bien gagner bagay nous gain option, gen certains bagay que nous capable faire et si nous gain succès là-dedans yo, y a payer service offre avocat yo qui travaille pour arriver dans résolution ça pour nous.
So just remember that the FMLA was created to protect workers like you from some of life's most difficult and important moments. And if you believe your employer has denied you the leave or interferes with your rights to take care of your family or yourself, you don't have to fight alone. You can call our office, of course, 954-523-5123 or 305-545-5123.
Et si ou même ou ta ouais que c'est un monde qui besoin genre de service ça, ou obligé camper pour faire bataille ça pour compte tout. Eh bien, M. Jonathan Ken l'a campé avec vous pour faire bataille là. Ou capable l'île dans bureau li, téléphone yo c'est 954 523 51 23 ou non 305 545 51 23.
So as we finish up, I want to remind you, Florida is what we call an at-will employment state, and that means your employer can fire you for almost any reason or for no reason at all. And on the same law, you as the employee can leave your job at any time without giving notice.
Nous capable rappeler ou sous affaire code du travail là en Florida, travailleur li capable quitter travail là l'elvle et boss travail là capable révoquer l'elvle.
However, there's federal laws, not Florida, but federal laws that protect you and say that the employer can't fire you or take negative action against you because of your race, religion, national origin, sex, or age.
Mais gen loi fédérale, si yo aller à l'encontre de sa règlement fédéral yo eh bien là ça nous même nous gen recours parce que là ça si yo al faire des actes discriminatoires contre nous, eh bien sous raison discriminatoire yo nous capable signer yo.
They also have protections for pregnancy here in Florida. And if you believe you've been discriminated against, you need to make a claim either with the EEOC, that's the Equal Employment Opportunity Commission, and Florida has a commission as well, the Florida Commission on Human Relations. Either one works. They both are the prerequisite. You have to file with those agencies first, and they will determine if they believe there's discrimination.
Et si ou même ou ta croit que révocation ça a un rapport à discrimination, eh bien, il y a un département employement commission, soit sous zone fédérale ou sous Florida, que nous capables de faire déclaration ça avec eux avant que nous capables de mener leur ça.
Remember that if you're fired without a reason and your boss doesn't give you a reason, that doesn't automatically mean the firing was illegal. Many employers simply don't want to explain themselves, and they don't have to. And I think that's what's very difficult for clients to understand. But if the circumstances suggest that you were fired because of one of those, the race, religion, disability, or age, then that might be illegal.
Alors, pas oublier que vous pas obligé de nous une raison. Et si que nous-mêmes nous suspectons, pour compte pas nous, gens ça a déroulé, peut-être ça capable de un rapport avec l'âge, non, avec religion, non, avec association politique, non. Le ça, nous capable de prendre route pour nous chercher déterminer si il y a une discrimination qui est faite contre nous sous base ça.
Also, if you were fired right after you complained about a discrimination or harassment or asking for FMLA, that could be retaliation, and that could also be a claim that you could file against your employer.
Alors, si vous même immédiatement vous demandez un livre d'absence et puis comme réponse c'est révoqué, vous capable de voir ça, c'est payer, il faut payer parce que vous avez demandé lui. Then vous capable et gon bagay ou ka faire ça.
Now, if you believe there's discrimination, first of all, you want to document everything. Keep any emails or write down any dates or conversations that you've had, because the evidence is going to be helpful. And then you must file a complaint with the EEOC, Equal Employment Opportunity Commission, or you can go to the Florida Commission on Human Relations, but I do believe the EEOC is more effective. And there are deadlines, so you need to do that as quick as possible, because these deadlines can bar your claim from being able to go forward.
Alors, si vous avez déterminé ou pensez qu'il y a une discrimination qui t'a fait contre vous, eh bien, on est capable de contacter le département EEOC pour capable déposer une complainte en détail de qui ça qui fait que faut qui constitue un acte discriminatoire.
The reason you have to go to the EEOC is that they have to do an investigation, and they will either determine if they're going to take the case on from your behalf and sue the employer for you, or most of the times, if they don't have enough evidence or they don't want to take the case on, they're going to give you something called a right to sue letter. And that's a letter that now gives you the right to file a lawsuit either in state and federal court with a private attorney, but you must go through that EEOC process first and get that right to sue letter.
Raison qui fait l'important que pour nous contacter EEOC au plus vite que nous pensons qu'il y a une discrimination faite contre nous, c'est parce que vous-même vous gagnez pour vous mener une investigation. Mener sa discrimination antérieure. Et si vous déterminez qu'il y a une discrimination qui est faite contre nous, vous soyez capable de décider pour présenter nous dans le cas pour nous assigner un travail là, ou vous êtes capable de nous une lettre qui nous doit pour nous assigner un travail là avec un avocat privé.
Now, understand, if you're successful, most of the time that's going to entitle you to have a reinstatement of your job. You get your job back, which not everybody wants. Not everybody wants to go back to the same place, but that's what the law provides. Get your job back, get back pay and lost wages for the time you've been out of work.
La loi prévoit si nous sommes capables de retourner dans le travail, ça, mais bien que la majorité des gens ne veulent pas travailler, non, retourner travailler à un côté que discriminer contre et ou gain droit pour toucher paiement que tu as dû payer ou si que pas fait acte discriminatoire ça contre.
There are some cases where there is compensation for emotional distress, and also in cases where you can prove it was willful and wanton, you can even get punitive damages against your company. And if you win, the payment of your attorney's fees and costs, just like the other areas of the law.
Gain pile instance côté que si nous gagnons dans cas ça yo, non seulement que nous capables de retrouver travail nous capables de retrouver l'argent parce que yo même été privé nous de travail là sont raison discriminatoire. Mais tant que l'autre cas yo, avocat au service que le fait, yo a payé pour travail ça.
So some examples would be a woman is fired a week after telling her boss she's pregnant. That might be a pregnancy discrimination case.
Alors, si yon moun nan travail, il t'a dit, boss travail la li enceinte, et puis, une semaine après, il révoque elle sous base ça, et c'est parce que l'enceinte, il va faire qu'elle là.
Or a longtime worker in a warehouse who's 59 years old and they replace that gentleman with a 25-year-old after years of positive reviews. They love the guy, but they just fired him and got a 25-year-old to take his spot. That may be an age discrimination case.
Et si vous avez travaillé en côté pendant des années, ou pas jamais aucun complaint contre vous, et puis soudainement, vous avez 59 ans, et puis vous décidez, vous aller pour l'autre monde 25 ans, de nous capables de constituer ça son discrimination d'âge qui fait que vous aller.
Another one might be a server that works in a restaurant and is fired after complaining to her boss that her tips are being skimmed by the management and they're taking some of her tips. That could be what we call unlawful retaliation.
Peut-être son monde qui travaille comme waiter, qui servi manger, qui servi dans un restaurant ou quelconque, et dans type qu'on recevoir, management nan yo prend yo séparer la l'autre monde yo même tout. Eh bien dans cas ça va le faire complète, yo révoque pour ça. Donc révocation ça li mal fait.
So just to close it out, as we're coming to a close of what you need to know about the law, in Florida, an employer can fire you without giving a reason, but they cannot fire you for illegal reasons. And we spent the hour this morning going over the types of illegal reasons like discrimination, retaliation, or filing of an FMLA claim.
Alors nous parler en grande manchette jeudi concernant loi travail dans Florida, qui ça qui constitue comme discrimination et qui genre que travail là capable révoquer ou même capable quitter tout et qui l'est que une discrimination qui sont capable faire comme ça.
I will say, if you believe you were terminated and it was unlawful, the most important thing that I want you to remember today is to act quickly. The law provides some protections, not a lot, but there are some protections, but the deadlines are quick and evidence disappears quickly. So if you don't get on it quickly, I typically think that can be an issue. So if you think it's an issue, you should definitely move forward. You can call the EEOC. You can call our office and we'll be glad to help you.
Alors, si on a déterminé que révocation ça a un rapport avec discrimination sous base que nous avons mentionné là, ou capable le département EEOC pour déposer complainte ou capable le cabinet de Jonathan Ken pour parler avec lui pour capable aider à gérer problème ça.
It's hard to believe that we've come to another close of what you need to know about the law, but we have. But the good news is we're here all week for you. We're not just here on Saturday morning. So if you have a legal question, if you have a legal problem, or if you have a question about the law, you get involved in a car accident, a work accident, you just need help, give us a call, 954-523-5123 or 305-545-5123. Want to wish you a wonderful weekend. God bless and bonne fin de semaine.
Alors, tant nous arrivons pour aujourd'hui, nous remercions tout le monde qui t'a écouté matin là. Nous invitons nous tous, les mettre Jonathan Ken avec n'importe quel problème légal que nous gagnons. Dans 954, 523, 51, 23, ou dans 305, 545, 51, 23. Merci et une bonne fin de semaine.
Expérience et connaissance yon avocat qui comprennent qu'il dit haïtien nan, c'est que les nan choisi yon moun qui pourrait représenter ou dans domaine légal. Cabinet avocat Jonathan Ken ak Franz Vital qui réputation solide dans occuper affaires immigration, divorce, loan modification, foreclosure, accident travail, accident automobile ak tout l'autre cas légal. De pour faire yon accident machine, osno yon accident de travail, relé met Ken ak met Vital. Yo ge capacité pour yo aider ou. Yo travail dit pour yo jouer une compensation dommage ou gagnant mérité. Yo tellement sérieux, si yo pas jouer l'argent pour vous, yo même yo pas toucher. Qui donc yo obligé travail pour capable jouer l'argent. Et tant ou toucher plus, yo plus content. Pas de accident qui trop petit. Relé kounia pour quel que soit accident. Mettre Vital qui des offices pour servir. Dans Broward 6190 Northwest 11e Street dans Sunrise.
Proverbe la dit malheur pa gen klaxon, mais joindre un monde qui pour défendre nous correctement dans cas malheur, ça c'est mission avocat Jonathan Ken. 954 523 5123. Il a plus que 30 ans depuis qu'il campé avec la communauté haïtienne, côté que lui aide des milliers de familles joindre justice. Accident machine, accident de travail, erreur médicale, avocat Jonathan Ken campé là. La responsable qui est sous personnellement ou a bien un numéro de téléphone cellulaire li, et l'a toujours mette intérêt famille ou avant. Sak pi bel la, consultation gratis. Si li pa ka aider ou, la préféré ou yon moun ki capable. Relais avocat Jonathan Ken jodia dans 954 523 5123, avocat Panou kap goumé pour communauté noire depuis plus que 30 ans. Et comme remerciement à communauté, avocat Jonathan Ken a chargé 28% seulement au lieu de 33%. Mais c'est pour mentionner réclame ça.